democracy, it's a liberal document, it's a liberal document, so on and so forth. Does it mean that social conservatism has absolutely no place within the meaning of the Constitution? Does it mean that the society does not have the right to draw a few red lines to put down the rigor of my submission to the extent of saying, I believe that they have a cause. I just don't believe they have a case. I draw from Hindu law here that the purpose of marriage or the object of dampatya is a child, is procreation.
Now, we perhaps are aware of how to read these judgments.
Please.
We don't need to be taught.
No, Millets, I'm sorry. I understand. I'm just placing reliance on this. I'm just making this up. The question of legislative competence is just one aspect of the issue which hinges on separation of powers. But I go a step further, which is to say that when the petitions raise the question of change in heteronormative attitudes, does the society have a right of agency to participate in these proceedings or not, at least in this particular issue or not? Because this is not a question of separation of territories between different organs of the state, but it fundamentally hinges on the right or the agency of the society to participate in this particular discussion. And that is the central problem when these kind of issues and subjects are taken up by the court of law, as opposed to leaving it for legislative prerogative to apply its mind. Point number two, during the course of these proceedings of the last 2 weeks, quite a few times I've heard the submission being made that it's a liberal democracy, it's a liberal document, it's a liberal document, so on and so forth. Does it mean that social conservatism has absolutely no place within the meaning of the Constitution? Does it mean that the society does not have the right to draw a few red lines to basically say thus far and no further? That is the central question. I represent a women's organization which equally represents the right of children. And therefore, as a civil society organization, the question that is being raised is that the nature of the prayers raised in the petition has the consequence of individualizing a socio-centric institution such as marriage, which is to say, as long as it is a transaction that takes place between two individuals who are consenting and who are not prohibited by any prohibition of degrees, so to speak, the rest of the society has absolutely no say as far as this institution is concerned. This, I'm sorry to say, fundamentally demeans the institution of marriage and takes away its social character. So these are the meta questions that I think which arise for consideration before this honorable court when these kind of petitions are filed. I'm sorry to say this, and let me try and perhaps tone down the rigor of my submission to the extent of saying, I believe that they have a cause. I just don't believe they have a case. The cause is different from the case. And it is important for the court to seriously consider one aspect here. When there are issues of legislative competence, there's another figure, so to speak, which is involved. And that figure's powers come under Article 111 of the Constitution, which is to say that if a legislative proposal ultimately meets with the consent of both the houses, ultimately it has to go to the Honorable President. And the Honorable President also has the power to recommend amendments to a legislation. Therefore, this is not just a question of legislative prerogative or legislative sovereignty, either from an external or an internal perspective, but there are multiple dramatis personae and stakeholders of this particular equation, the society being the chief. Because ultimately, the petitions raise the question of changing the paradigm with respect to heteronormative attitudes of legislations in general. It is not just about the SMA. Plus, my lords, is not dealing with the religion-specific legislation here, it is the SMA, which means all the more the society's participation when it comes to the SMA is warranted, is mandated, is compulsory. Because at least if it were to be with respect to certain, let's say, religion-specific legislations, it can be said that there is an identifiable group which has a locus to argue here. But when it comes to the SMA, it can't be the argument that only those who subscribe to the values of SMA are allowed to participate in these proceedings. Secondly, as has been already submitted, Section 21 of the SMA has a direct bearing on personal laws. So even with respect to SMA, the society has a right to participate. If I may say so, and I say this with the deepest of respect and the greatest of humility that I can command at this point, that the judicial mechanism cannot be a substitute to any of these steps, especially when it comes to such a serious issue. And I draw from Hindu law here that the purpose of marriage or the object of dampatya is a child, is procreation. Now, therefore, comes the central question with respect to all the permutations and combinations which my lords posed by way of circumstances. What happens to a single child? What happens to a single parent? What happens if it's a homosexual single parent? So on and so forth. Allow me to answer this question in a slightly different fashion. Public morality is decided by normative attitudes. The norm is decided primarily by the mainstream. This is not a majoritarian argument. This is a statement of fact in a democracy. Point number two. when normative attitudes are sought to be revisited, to say that those who constitute the norm don't get to participate in this discussion because that particular process and that particular, let's say, dance of democracy is sought to be circumvented by using the instrumentality of the court to secure a certain outcome, I'm sorry to say, defeats the purpose of advocacy. Those who are interested in convincing the society are expected to engage with the rest of the society to make good their cause. The judiciary cannot be a substitute to this particular process, because then that effectively replaces societal cogitation with, I'm sorry to use the words, judicial paternalism. That can't happen. 3, the benefit of revisitation of a judgment with respect to such sensitive issues, even if it exists by way of clarifications, I'm sorry to say, is not an adequate substitute, it's a suboptimal substitute. Because if the principle that has been established by several judgments is that a judgment is not to be read in the manner of a statute, then there is no precision which can be imparted to the language or findings. And therefore, the principles of statutory interpretation don't apply. So we are left with greater uncertainty. It's our judgment that they placed reliance upon extensively. There is a plus and there is perhaps a downside to it. The plus is the judgment must be read in its context. And the issue was the recognition of a third gender. That was what it was limited itself to. And therefore, to extrapolate the findings of the particular judgment, which primarily concerned itself with self-perception, self-identification in the context of gender identity, to extend it to a marital transaction or a marriage-like transaction is to read a judgment for what it is not. Secondly, there are only 3 places.
I think we perhaps are aware of how to read these judgments.
Please.
We don't need to be taught.
No, Millets, I'm sorry. I understand. I'm just placing reliance on this. I'm just making
Yes, we understand that these are contexts.
Please.
Whether they're analogies or not is up to us.
My lords, please, Millets. I'm grateful. The second point is, in fact, on a closer reading of this particular judgment, certain inconsistencies emerge between the 2 opinions of the very same bench in terms of what constitutes sexual orientation, what constitutes gender identity. Now, that is natural because there is a discussion that's going on there. It is not to be read in the same manner as a statute. In fact, therefore, the judgment, which doesn't exactly help their position, also points to a certain problem with respect to judicial revisitation of some of these aspects. And the judgment of Arun Kumar of the Madras High Court is actually in the teeth of the submissions being made here, which is to say narrow language being expanded through judicial interpretation contrary to legislative intent and history, is to rewrite legislative history, and judicial reinscription, which is retrospective in nature, may not be exactly permissible. That's one. Then, Millards, the submission with respect to international law, all the general instruments apart, the Yogyakarta principle, specifically clause 24.e, specifically leaves it to countries to decide if they wish to have recognition with respect to marital unions. So it's not as if there is some kind of a binding precedent here, or there's no international instrument that says that you shall. I'm not arguing for it should not be. Kindly let this caveat is important. I'm simply saying, if the door of judicial intervention in this matter is open for one case, even though the cause may be worthy, what does it do for the future? Because ultimately, it's not just a question of one matter. It's a question of the future as well. So therefore, there are specific aspects that relate to the issue in question, and there are general aspects that relate to the separation of powers and societal participation that go well beyond this matter. In light of this, my lords, my only humble submission is that there are other issues to be dealt with, and allow me to just point this out and use this particular forum to advocate only one aspect. Having actually engaged with certain transgender activists and also having worked with them, I know for a fact that one of their biggest problems is trafficking, them being pushed into prostitution, them not having legitimate livelihoods. I am not reducing or dismissing anybody's concerns with respect to what is their priority. Let me clarify that. I'm not making that submission at all. But these are certain Maslow's needs which have to be completed first and which have to be addressed first before we get to the next step. That's all I have to submit. I'm so grateful for the kind, please, it's great, deeply obliged.
Now, Mr.